I'm going to let you in on a little secret. In common law countries like the United States, the law is practiced largely by comparing your case to all the other cases and finding things that are the same or very different. It's like a complex spot the differences exercise. As lawyers, we're working to compare our facts to those facts and explain why they should or shouldn't be treated in the same way. Sometimes the application is straightforward, and it makes a lot of sense. And sometimes, like today's case, it asks us to treat a single incident as a pattern. This is Conduct Unbecoming. I'm Erin, and I'm your host. A quick listener's note before I delve into the facts of this case. This is a sexual assault case. If that means that this episode isn't for you, all good. Catch me next time. On Tuesday, April 10th, 2007, CL, who I'll refer to as Carly, spent time with a family friend, Specialist Jackson. Carly's husband had just deployed to Iraq, and prior to his departure, he asked his friend, Jackson, to look after Carly. She would be caring for their child alone and suffered from anxiety. Her husband heading to a country still in active turmoil certainly wasn't going to make her less anxious. That night, Carly put their child down at around 8:30 and began to drink at about 9 p.m. Before getting ready for bed, she drank about 1/3 of a pint of gin, or between 3 and 4 shots. In order to get ready for bed, Carly took 2.5 milligrams of her prescribed Xanax, so she could begin to wind down and get some sleep. Xanax is used to treat both anxiety disorders and anxiety caused by depression. It can also be used to treat panic disorders. And the thing about Xanax is that when mixed with alcohol, both become more potent. It can lead to exaggerated sedation and make people clumsy or more accident-prone. It can also have a negative impact on someone's memory. Earlier in the day, Carly took 0.75 milligrams of Effexor. Effexor is a serotonin-norepinephrine reuptake inhibitor, or SNRI. It too is used to treat depression, anxiety, and panic disorders. Shortly after Carly took her Xanax and began to prepare for bed, a friend of hers, who I'm going to refer to as Vanna for ease, called and said she was coming over. I've been the pushy friend that wants to come check on someone when their spouse is deployed, but I usually do it in the daytime. Vanna brought with her Private First Class David Ellerbrock and Private Paige. Specialist Jackson was still there, and everyone socialized together. Ellerbrock and Carly had met earlier in the year before Carly's husband left on deployment, but they didn't really know one another well by any means. This brought the total number of adults in the house up to 5, which seems like a lot for a random Tuesday evening. When the party got going, Carly drank 2 hard lemonades. Some accounts indicate that Carly also snorted a line or lines of Xanax, which seems like a pretty big detail to be in disagreement about. It's a little confusing because by 11 p.m., Carly was a little louder than usual and a little bit stumbly, but otherwise fine without any other major signs of intoxication or impairment. The party was beginning to run low on supplies, which I'll assume means alcohol, and both Jackson and Vanna went on what I assume was a beer run. That left 3 adults in the house, Carly and 2 men who were relatively unknown to her. Private Paige left to sit in his car to wait for Jackson and Vanna to return. Now, where I get confused is that Vanna said that before she left on the beer run, Carly was passed out in the bathroom after having vomited. And that feels like a pretty major sign of intoxication or impairment. And hey, just a reminder to everyone, we don't leave our unconscious friends alone with near strangers. Jackson, however, disagreed about Carly's condition and said Carly was either on the couch or on the bathroom floor, but that he couldn't recall which. Being on the bathroom floor, however, was consistent with what Vanna said. Private Page said that before he went to sit in his car, Carly didn't seem to be passed out or blacked out. Everyone agreed, though, that she was highly intoxicated when she was left alone with Ellerbrock. And I have to think that there was something that felt off. Because it's weird to leave a hang to go sit in a car waiting until Vanna and Jackson returned. Something about being in the house clearly made Private Page uncomfortable. It was about 30 minutes after he left to his car that Vanna and Jackson returned. And when they returned and discovered Private Page outside, only Vanna went inside the home. Less than a minute later, she returned and told the men she heard sexual noises coming from inside the bedroom upstairs. Private Page remembers this differently and said that Vanna returned and said Carly was passed out in the bathroom, which again seems consistent except for the timeline with Vanna's testimony that Carly was passed out when Vanna and Jackson went on a beer run. I think it's safe for us to conclude that at some point Carly was lying on the floor of the bathroom. It's unclear whether she was confirmed to be unconscious. And it's equally challenging to figure out when she was on the floor of the bathroom. Given what happens next, it seems unlikely that Vanna emerged from the house and told Private Page that Carly was passed out in the bathroom. When the men went inside with Vanna, they too heard sexual noises. Specifically, they heard the bed squeaking and they heard moaning. Private Page only heard Ellerbrock, the male voice. Jackson believed he also heard a female voice. Vanna opened the unlocked bedroom door, turned on the lights, and discovered Ellerbrock and Carly engaged in vaginal sex. Jackson said he saw Carly flinch when the light turned on, but she otherwise just laid there, head limp, eyes closed. Private Page didn't see Carly move at all, and he believed she had no control over her mental or physical faculties. No one testified that she appeared alert. A toxicologist later testified that Carly would have exhibited anything from minimal effects of sedation to being pre-comatose. Vanna attempted to intervene and told Ellerbrock to get away from Carly. He responded by telling the group to leave because he was almost done. He asked them to close the door on their way out. Carly didn't respond to the intrusion. The three did, in fact, leave. They left both the bedroom and the house as a whole. Carly called Jackson the next day and said she remembered the incident with Ellerbrock, which she described as having sex with him. She claimed to be in disbelief and horrified at her actions. 2 days later, Carly reported the incident to Criminal Investigative Command and submitted to a forensic examination, the results of which were introduced at trial. But we're not going to get into the details of her injuries. Ellerbrock pleaded guilty to conspiracy, destruction of military property, larceny of military property, larceny, and housebreaking. Housebreaking is more breaking and entering and less home wrecking. I genuinely have nothing to offer about why Ellerbrock was charged with conspiracy, destruction of military property, larceny, or housebreaking. Details of these offenses are not included in the appellate opinions. Ellerbrock pleaded not guilty to rape and sodomy by force. The court-martial therefore revolved around whether Ellerbrock assaulted Carly, whether Carly consented. Ellerbrock learned that Carly had an extramarital affair, and he moved to admit evidence of that affair. This, he thought, would bolster his contention that Carly, allegedly unresponsive and potentially unconscious, consented. Ellerbrock alleged that Carly's affair made it likely that she would lie about the nature of their encounter, that Carly would make false allegations of rape. 3 eyewitnesses saw Carly and Ellerbrock having sex, but their testimony about her mental capacity before and during the alleged rape varied. Kind of. Carly's testimony as to her consent, therefore, was critical to the prosecution's case. I know I've covered a fair range of stereotypes about service members, but there are plenty of, let's say, unflattering stereotypes about military spouses, too. Some people believe that military spouses get married only for the benefits, that sweet, sweet TRICARE coverage. I suggest that those people haven't tried to reestablish care moving every 12 to 36 months. Others think that military spouses become sexually promiscuous the second their spouse deploys. You know, the basis of Dear John letters. This particular stereotype lends us a framework for looking at this case. Carly and her husband married in August 2004. They lived separately at first. Carly lived with a female roommate in Jacksonville, Florida, while her husband was stationed 2 hours away at Fort Stewart in Georgia, kind of near Savannah. Carly's roommate allowed a male friend to move in. Approximately 1 month later, Carly and the male roommate began a sexual relationship. The affair ended on its own in December 2004. And when they parted, Carly felt guilty and confessed the affair to her husband. Well, to her husband, her parents, her friends, and a neighbor. Carly feared that her husband would leave her over the affair, but she came clean to everyone nevertheless. Her husband didn't threaten to leave Carly, but he did become rather aggressive, learning of Carly's infidelity, and he visited the man, where he kicked down his door. He spent 3 days in a Jacksonville jail as a result. But Carly and her husband moved forward. They had a child, and they believed and testified that the confession and fallout made their marriage stronger. They were in a good place 3 years into their marriage, when the incident between Ellerbrock and Carly happened. I'd offer that Carly, at the time of the alleged rape, was in a particularly vulnerable and undesirable position. She was on multiple anti-anxiety medications, likely removed from her family and her support system because that's just the nature of military moves, functionally single-parenting her 2-year-old while her husband was deployed. She had people show up to her house to party on a random Tuesday night. Then, the 2 people she actually knew, Vanna and Jackson, left her in her home with 2 men she knew of but didn't know well. They'd seen her mix Xanax with alcohol and become, by some accounts, unstable and visibly intoxicated. This is, all to say, a significantly different background than the 3-month affair with a man she lived with and knew well. The military judge overseeing Ellerbrock's court-martial for rape determined that it was only marginally relevant to show that Carly had a motive to lie. The affair was stale, because it happened 2.5 years before the alleged assault, and because there was nothing to suggest a second act of infidelity would result in divorce. Carly and her husband, after all, had grown together after the infidelity, and had a child now to consider. So, the judge declined to allow testimony on Carly's affair. Ultimately, the panel convicted Ellerbrock of the sexual assault charges and sentenced him to a dishonorable discharge, 25 years of confinement, forfeiture of all pay and allowances, and reduction to E1. When confronted with the testimony about the victim's extramarital affair, the court-martial judge had to decide whether the evidence was admissible or if it was barred by Military Rule of Evidence 412, or MRE 412. MRE 412, which is analogous to Federal Rule of Evidence 412, is the Rape Shield Law. It restricts the admission of evidence of a victim's other sexual behavior and encounters. The rule was intended and created to shield victims of sexual assault from embarrassing and degrading cross-examination and evidence presentations. Before the rule's creation, trying to prove up that someone was promiscuous was a common way to attack their credibility, their believability as a victim. The rule is designed to prevent a defendant from using innuendo and propensity to demonstrate consent. The rule, notably, is a rule of exclusion. The default is that the evidence doesn't come in unless it's first, relevant, second, material, and third, the probative value of the evidence outweighs the victim's privacy interest. And I want to get this out of the way. The quote, perfect victim is rare. Stranger rape is uncommon, so there's often some kind of relationship between a victim and a perpetrator that gets picked apart at trial. Not all victims fight back or immediately report. And not all victims have led a purely monogamous, romantic life. That doesn't mean that they weren't assaulted. The military judge balanced that shielding intent against the probative value of the evidence. She considered whether there was a danger of unfair prejudice if she admitted the evidence. She had to consider whether the panel would be confused if the evidence of Carly's affair was put before them, whether they might mechanically acquit Ellerbrock because Carly wasn't the perfect victim. Ellerbrock was still free to argue that Carly consented, and that she had a reason to lie about it after. He could still argue that Carly, caught in the act that he asserted was consensual by her husband's friend, Specialist Jackson, was lying about her role. That's exactly what defense counsel did. In closing, he argued that Carly had to offer some kind of explanation for the events of that night. Her husband's best friend, his close friend, Specialist Jackson, was there, and witnessed most of what happened that night. Specialist Jackson, who Carly called the next day to discuss what happened, who Carly told she remembered having sex with Ellerbrock. All of this played out in front of the panel, and they convicted Ellerbrock anyway, because they weighed the evidence and the credibility of the witnesses. The Army Court of Criminal Appeals agreed with the court-martial judge and further concluded that the defense never actually tied Carly's husband's reaction to the affair to any motive to lie. That there is nothing in the record that the husband's aggressive reaction jeopardized his marriage to Carly. It's a nuanced argument that relies on the fact that Carly's husband's reaction was to the other man, and not to their marriage. And this, following their logic, could manifest a fear for Ellerbrock's safety if Carly had consented, but shouldn't be the basis for concluding the marriage was in jeopardy. However, the Court of Appeal for the Armed Forces found not only that the testimony was not barred by MRE 412, it was actually constitutionally required to admit the evidence in order to protect Ellerbrock's Sixth Amendment right to confront the witnesses against him. Part of confronting this particular witness was the right to cross-examine, impeach, and discredit the witness. CAF concluded that the record indicated Carly didn't want her marriage to end, and this tended to show that she had a motive to lie about whether or not she consented to sex with Ellerbrock. They did not believe the affair to be stale because Carly might fear that her husband would leave her. They held that the probative value outweighed the risk of prejudice, and any potential prejudice could have been contained with well-crafted instructions to the panel. And I think CAF signaled pretty early on how this was going to go. They continually referred to the evidence as evidence of Carly's first extramarital affair. It was evident they believed this case was a matter of Carly's second extramarital affair. Otherwise, there's no need to number them. It's not the job of the appellate court to make findings of fact, and they are not in a position to do so, consulting only trial transcripts and exhibits. In the way they crafted their opinion, it certainly feels like they were concluding that this was a second affair, that Carly was lying about consenting. They used the affair Carly had as essentially propensity evidence, the exact sort of evidence MRE 412 was designed to prohibit. The signals CAF sent in their writing choices really got my hackles up. It seemed that CAF tried to make a pattern of promiscuity out of one affair. Patterns require repetition. As the court-martial judge concluded, there was no pattern of rape allegations, and there was no pattern of extramarital affairs. I'm not going to go so far as to say that CAF bought into some of the least forgiving stereotypes about military spouses during deployments. But I am going to say that they weren't in a position to conclude that this alleged rape was an affair. Outcome aside, this wasn't my favorite opinion to read. CAF chased their tails for a few pages to conclude that Carly's affair and her subsequent fear of divorce affected her believability on the issue of consent. They decided that the affair may have established a greater motive to lie about the issue of consent in this case, but there is nothing in the record to show that the affair actually did give rise to motivation to lie. The majority opinion concluded it was common sense that a married person who was previously unfaithful was likely to later fabricate a rape allegation with a stranger than someone who didn't have the same blemish in their sexual history. I was annoyed by this, quote, common sense conclusion because it's not really about married people. It's about women. It's about not believing imperfect women who testify to sexual assault. I don't often cover sexual assault cases, in part because they're potentially very triggering for you and other listeners. This case taps into the rest of the reason I don't like to cover these cases extensively. The opinions offered here have very little to do with Ellerbrock or the crimes he committed or this one that he may have committed. Each fact section is a recitation of the victim's history, as though she was the one on trial. I can tell you about the state of Carly's marriage, her embarrassment at her indiscretion when she was newly married, that she would be embarrassed to have the panel learn of her infidelity, but accepted that if it came in, it came in. But I can't tell you why Ellerbrock was charged with and convicted of larceny. I can't tell you if the larceny has to do with this particular incident. I can't tell you if the panel heard about the charges he faced and pled to that might establish some kind of pattern in his behavior. I found that the belabored point-making in CAF's opinion did little except highlight that this was a challenging conclusion for them to arrive at. And if it was a close call, and I'd offer that it was, CAF should have left the ruling alone. The standard of review on appeal for an MRE 412 ruling is abuse of discretion. The appellate court should only disrupt the ruling if the trial judge abused their discretion in making the decision. This could be demonstrated if the judge made clearly erroneous findings of fact. And for all of the wandering that CAF did, they didn't hold that the military judge's findings of fact were clearly erroneous. They didn't really lay a foundation as to an abuse of discretion, and I just wasn't convinced. CAF reversed Ellerbrock's conviction for rape and sodomy by force, and that's where the paper trail ends. It's unclear, based on publicly available records, whether the Army tried Ellerbrock again. If they did, an appeal didn't make it to the ACCA. A retrial would have necessarily included testimony about Carly's affair, and perhaps that was untenable for the trial team. Or maybe Ellerbrock accepted some kind of plea deal to avoid a second trial. Thank you for listening. If you enjoyed today's episode, please be sure to subscribe to Conduct Unbecoming wherever you listen to podcasts. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com or on conductunbecomingpod.com. Join me next time when we learn a little too much about friendly fire. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, endorsed, or authorized by the Department of Defense.